Welcome back to the second segment of this law session on precedent in light of judicial reasoning. Now, we looked at before what precedent was about in the last segment, and I started looking at the hierarchy of the courts, and I went through more or less the Supreme Court. We looked at the Court of Appeal, and also we looked at the High Court. What I wanted us to now continue on is to look at the courts below that. Now, the Crown Court is bound by all the courts that we had mentioned before, the House of Lords, Court of Appeal, and some of the High Court decisions as well. Now, its decisions do not form binding precedents, though when the High Court judges sit in the Crown Court, their judgments form persuasive precedents, which must be given serious consideration in successive cases, though it is not obligatory to follow them. Now, when a circuit judge or a district judge is sitting, no precedents are formed. Now, since the Crown Court cannot form binding precedents, it is obviously not bound by its own decisions. When you look at magistrates and county courts, and I throw them together because when you look at the district judges who sit in the county court, you also have the district judges in the magistrates court as well. These are inferior courts. They are bound by the High Court, Court of Appeal, Supreme Court. Their own decisions are not reported and cannot produce binding precedents or even persuasive ones. Like the Crown Court, they are therefore not bound by their own decisions. What about the European Court of Human Rights? Well, the European Court of Human Rights is an international court based in Strasbourg, and it hears cases which allege that there's a breach of the European Convention on Human Rights. Now, this court does not necessarily fit neatly within the hierarchy of the courts, but what you have to bear in mind is that under Section 2 of the Human Rights Act 1998, an English court is required to take account of the case law of the European Court of Human Rights, though its decisions do not bind the English courts. In practice, though, when considering a convention right, the domestic court tried to follow the same interpretation as that given by the European Court of Human Rights. That then are the courts generally. Question: how does judicial precedent work? Well, the idea, as I've mentioned, is stare decisis. And we talk about standing by the decision. Let's look at some of the cases. If we start off with the well-known case of Donahue and Stevenson, which is a 1932 case where we have Lord Atkin sitting and formulating his now famous neighbor principle. In the case, the decomposing snail was found in a bottle of ginger beer. Now, the House of Lords said that a manufacturer owes a duty of care to the consumer that their products are safe. Now, in the case, products, as in that case we saw there, it was the ginger beer and the fact that the snail was in it. But products have since been held by later courts to include not only food and drink, but other things: underpants, motor cars, hair dye, chemicals. And in the case of Grant and Australian Knitting Mills in 1936, the claimant had bought some underwear, but the material contained a chemical which caused dermatitis. Now, compensation was awarded on the basis that when you look at a manufacturer and his duty in respect of products, we see that in Australian Knitting, it based its finding on the precedent set by Donahue and Stevenson. Now, what about ratio? Looking at the crux, the heart of the case. Well, if we look at the case of Dudley and Stephen, the Crown and Dudley and Stephen, which is an 1884 case, we see two shipwrecked defendants who killed and ate the cabin boy because they were stranded out in the sea. Now, they were convicted of murder. Now, the court gave 3 reasons for refusing their defense of necessity. They basically said, look, we're stranded out on the high seas, didn't have anything we thought we're all going to die. So the way we looked at it was, let's eat him and then at least 2 of us survive. Question is, who decided that the cabin boy was going to be the one to be eaten? I'm sure he didn't have a say in that decision there. But the point is that when you look at the case, the defendants sought to argue that it was necessary for them to kill the cabin boy and eat him. The court, when they looked at the defense and in refusing it, they said, 1, if necessity is not available on a charge of theft of food because of starvation, it cannot be available to a charge of murder. Secondly, they said you have to look at the Christian aspect of giving up your own life to save somebody else's rather than taking somebody else's life to save your own. And thirdly, the impossibility of choosing between the value of one person's life and another. How did you all decide that he was the one to be eaten? Now, when we look at the 1987 case of the Crown and Howe, HOWE, the 2 defendants helped torture a man who was then killed by other men and, on a later occasion, killed another man. The House of Lords, in refusing the defense of duress to charges involving murder because of the need to protect innocent lives, to set a standard of conduct which all people are expected to observe in order to avoid criminal liability. So when you look at how it basically considered the ratio in Dudley and Stevens. What about remarks made, by the way, obiter remarks? Well, in Crown and Howe, the same case I've mentioned, the House of Lords commented, by the way, that a defense of duress should not be available on a charge of attempted murder. Now, that wasn't what was before the court, so that is why it was said, by the way. Although this statement was obiter, it was followed by the Court of Appeal and then the House of Lords in a subsequent case in 1992, R.V. Gotts, when a son attempted to kill his mother under duress from his father. Now, in a case of Hill and Baxter of 1958, a very misunderstood case by law students doing criminal law sometimes, this swarm of bees. Please remember the case was not about a swarm of bees. It was remarks made obiter regarding bees. Now, in Hill and Baxter, the defendant driver fell asleep, drove into some people. His conviction for driving offenses was upheld as he was at fault for not stopping when he felt drowsy. The judge went on to give a fictional example of someone being stung by a swarm of bees while driving and losing control of the car as an example of a driver not being at fault. So when faced with a case on which there appears to be a relevant earlier decision, the judges, of course, can follow that earlier decision, but of course, there are other things that these judges may do. Let's look at some of them. The first, of course, is that there is this idea and concept of the practice statement 1966. Now, the practice statement was accompanied by a press release which emphasized the importance of the reasons for the change in the practice. They said it would enable the House of Lords to adapt English law to meet changing social conditions. They said it would enable the House to pay more attention to decisions of superior courts in the Commonwealth. The change would bring the House into line with the practice of superior courts in many other countries. In the USA, for example, the US Supreme Court and the state Supreme Courts are not bound by their own previous decisions. However, the practice statement has rarely been used. It is not used a lot, very sparingly. Now, in R.V. Howe, the House of Lords declined to follow the decision in Lynch and the DPP for Northern Ireland, which is a 1975 case, where they had held that duress was available as a defense to accomplices to murder. Now, the second way that a court may consider not necessarily following its previous decision, the case of Young and Bristol Airplane allows the Court of Appeal to correct its mistakes, which is especially important as it hears the most appeal cases. when compared to the House of Lords. Most cases in the UK actually finish at the Court of Appeal level, because the idea is you have a right of appeal to the Court of Appeal. But if you're going to move on to the House of Lords, you have to first seek leave from the Court of Appeal. If the Court of Appeal says no, you seek leave from the House of Lords. You can only go to the House of Lords on a point of law. So the point is, of course, most of your appellate frameworks are based on that. But the point is that you can be denied going to the House of Lords. So when you look at the Court of Appeal, it plays a pivotal role. Now, the extra flexibility in the criminal division is important, as such cases, as I said, involve the liberty of a person. Now, the main thing that we see in the context of precedent is the following of a decision. If the facts are sufficiently similar, the precedent which has been set by the earlier case can be followed, and the law applied in the same way to produce a decision. The court can distinguish. Distinguishing is where a previous case is only binding in a later case if the legal principle involved is the same and the facts are similar. So you can have cases where the facts are similar, but they have different principles. And that's what you're saying. Court, even though it looks like this other case, the principles are slightly different. Now, distinguishing a case on its facts or on the point of law involved is a device used by judges, usually in order to avoid the consequence of an inconvenient previous decision. Now, any judge can distinguish a precedent on minute details, and the difference can sometimes seem illogical. Now, distinguishing does allow the judge to develop the law and also to create exceptions to the general rule. Now, the case where the defendant had stabbed the victim or received negligent medical treatment, case of R.V. Smith, we see that the case of R.V. Jordan, where the victim died of pneumonia and the chain of causation was broken, was distinguished. So Smith was distinguished from Jordan. When you look at intention to create legal relations, Balfour and Balfour was distinguished from Merit and Merit. You can also have a situation where a case is overruled. This is where a higher court overrules a decision made in an earlier case by a lower court. Example, the Court of Appeal can overrule an earlier high court decision. Now, the European Court of Justice and the House of Lords can, as I say, overrule their own previous decisions. Lastly, reversing. If the decision of a lower court is appealed to a higher court, the higher court may change it if they feel the lower court has wrongly interpreted the law. Clearly, when a decision is reversed, the higher court is usually also overruling the lower court's statement of the law. And as we said, overruling is proving that the previous case was wrong and that they did not rely on the law as they ought to have. There, of course, this can be criticized, and certainly when you look at cases which have been overruled, you see that you have got to look at them very carefully. Now then, what I want us to do is to take a short break. We're going to come back and we're going to then consider further how the doctrine of precedent operates in English law, or continue looking at how it operates in English law.